नमस्कार फ्रेंड, आप सभी का स्वागत है। फ्रेंड्स, डॉक्यूमेंटेशन इज एन इंपॉर्टेंट पार्ट ऑफ द बैंकिंग। क्रेडिट ऑफिसर्स, ब्रांच मैनेजर को वेल अवेयर होना चाहिए कि डॉक्यूमेंटेशन कैसे होना है, क्या प्रिकॉशंस लेने चाहिए, क्योंकि डॉक्यूमेंटेशन हमारे एडवांसेस का एक महत्वपूर्ण पार्ट होता है। अगर बाद में प्रॉब्लम फंसती है तो हमें उसको डॉक्यूमेंटेशन के आधार पे हम प्रूफ करते हैं। फ्रेंड्स, दिस वीडियो इज वेरी यूजफुल फॉर द क्रेडिट ऑफिसर एंड द ब्रांच मैनेजर्स, so you please take a note and here listen very carefully. The main concern of the bank is that security available to it should be good enough to fall back upon in the event of the adverse circumstances. The role of loan documentation in the bank is to establish a legal relationship between the lender and the borrower when the dispute goes to a court of law. Thus, the execution of the loan is important to bankers to ensure that the document held by them is properly stamped, properly filled in, executed in relation to a specific security and nature of security, and having a record of the date and place where the document is executed. How to develop your time, how to devote your time to the execution of documents. The borrower guarantor shall execute the documents in the presence of the bank manager or the authorized official of the bank. The officer in charge of the documentation in bank must be thoroughly conversant with the type of securities and the legal nature of charges to be created. In the cases of illegal borrowers' accounts, bank take the services of the experienced advocate of the bank's panel for the purpose of documentation and also the executed. Documents to be vetted by the advocate or law officer of the bank. Hence, devote your time to the execution of documents and ensure perfection in the following matters. First, the documents should not be given to the borrowers for obtaining signatures from other borrowers or guarantors. Number two, the document should be executed in one sitting. Number three, the executor, borrower and guarantor should read the content of the documents prior to the execution. Fourth, the executor should sign in full on all the documents and not by initials. Fifth, the cutting, overwriting must be authenticated under the full signature of the executors. Sixth, while filling in the blank space of a printed form of stamped paper, use the same pen till the end of the form. Different color ink used to fill in the same form gives rise to the suspicion that the blank column was filled up later or without the knowledge of the executant, which is bad in law. Seventh, while filling the printed forms as an abundant precaution, the executant's signature shall be taken wherever a blank space is filled in by the others. Subsequently, the executant cannot later on dispute what the form was filled in later. Where a borrower is an illiterate person, a left-hand thumb impression of the borrower should be obtained. There is no need to attest to the thumb impression. However, if the borrower is an illiterate Pardhanisian lady or a person signing in a vernacular language, it is necessary to have a certificate stating that the contents were read and explained in the executants and that he or she executed the same of her own free will after understanding the sanction terms and without any correction. Sanction term and condition shall be conveyed to borrowers in writing, and acceptance of the sanction terms and conditions should be obtained from them. Proper documents, complete in all respects according to the nature of the facility, should be obtained. A minor is incapable of entering into the agreement and any agreement entered with a minor is void as per the Indian Contract Act. However, in some partnership firms, a minor might have been admitted as a partner of the firm. Banker must remember that such a minor is admitted to the benefits of the partnership and they cannot execute the loan documents. Hence, guardian signature should not be taken in loan documents on behalf of the minor. 11th, proper care should be taken that the only authorized signatory have executed the documents. A sole proprietor should execute the documents with the proprietary stamp in the representative capacity. 12th, in the case of a partnership, the document should be signed by all the partners or a letter of authority should be obtained from absent partners in favor of selected partners to execute the documents. It is necessary to obtain personal guarantee from all major partners in their individual capacities whenever a limited company is partner. The authority of the person signing on behalf of the company should be verified. In case of limited company, the execution of document should be as per the stipulation contained in the resolution. The resolution passed in the meeting of the board of directors should also clearly specify who could execute the documents on its behalf. Documents executed by the company should be affixed with a common seal only if it is required under the common seal clause in the article of association of company. If a common seal is required to be affixed, then the board resolution should contain the name of the director and the officer in whose presence the seal is to be affixed. 14th, stamp duty varies from state to state. Proper stamp duty as applicable to the state where the document is executed shall be paid. Any instrument chargeable with stamp duty executed out of India must be stamped within 3 months after it has been first received in India. In case of mortgage of property, the mortgage deed shall be executed on stamp paper of adequate value. If a memorandum of mortgage or mortgage deeds itself is registered, the receipt of the registration fee paid should also be attached to the mortgage deed. Boundaries and areas shown in the title deed should be conformity with the mortgage deed. 19. Encumbrance certificates traced for the last 13 years should be held. 20th. Up-to-date property tax paid receipt should be properly held. 21. All the original title deeds and the other relevant documents as per the legal opinion should be obtained and deposited in the bank. 22nd. Authorized person only to create mortgage. 23. Record of the dates to be observed in case of second charge. Pari passu charge and NOC should be obtained properly from the first charge holder. 24th. Valuation of the properties and the legal opinion should be kept along with the mortgage documents. 25th. Revival letters from borrower and guarantor should be taken before the expiry of 36 months from the date of demand of promissory note. Confirmation of balance is to be obtained from borrower and guarantors normally on a half-yearly basis. Attestation of documents. Attestation of documents means witnessing the execution of a document that is required to be attested under law. In case of documents like the assignment of LIC policies, one witness is required, and in case of the mortgage deed, there should be 2 witnesses. Some documents like demand promissory note need not to be attested. The executants are the party to be deed and they should not be attesting persons. The attesting person need not know the contents of the documents. Registration with the registrar of companies. ROC in case of the limited companies charge on the company's assets like hypothecation of stock and machinery, book debts, mortgage, etc. shall be recorded with the ROC within 30 days of the execution of documents in terms of section 125 of the Companies Act. The registration should be done with the registrar of the companies under whose jurisdiction the company's registered office is situated. And last but not least, have a second look at the documents executed before keeping them inside the safe. And if you find any other problem, kindly you must take vetting of the documents with the legal advisor or your chartered accountant or the law officer of your bank for safety and security of your own creditor in charge, branch manager, and the bank. The interest of the banks must be protected in any way. Thank you, friends. Namaskar.